second segment, we have a certified financial planner and hopefully a family law mediator as well. That'll come in the second segment. But we'll start off with Leigh. Now, we talked about there may be some money involved and there may be some numbers. We're going to start with cost-benefit analysis. And you're going to go down the road of the family law, of course, separation, but more specifically in the litigation space.
Correct.
Right? Give us some examples.
In the litigation setting, in a family law case, I cannot stress enough how important it is to do a cost-benefit analysis from the beginning of the case and really throughout the process. In family law, uniquely, emotions run very high. Understandably, we're dealing with the demise of a marriage. We're dealing with the division of people's personal assets, custody issues, and support issues. When emotions are running high, people's ability to plan logically and practically are diminished. So as a litigation attorney, one of my roles is to work with the clients to determine really what it is they're looking to gain through the litigation process. What assets do they want to parse out as their own? Secondly, we have to talk about what their chances of success are, given the current state of the law and the facts of the case. And finally, and most importantly, how much is it going to cost them to get to that end result? Because oftentimes, what a client might think is fair or reasonable is not always the most cost-effective path they should be taking when we think of litigation.
Got it. That does make sense. We're talking with Leigh Galyon. Her website is herveywood.com. That's their website, herveywood.com. The role of the judge and the court, this is kind of a way of taking the decision out of your own hands, right?
Absolutely. The judges in family law have a limited role in that they are obligated to apply the law to the facts. And the facts I reference are the facts that come in through admissible evidence. That would be another entire segment, but not all of the facts that the parties think are relevant will ever be presented to the court. The judge, in general, will have to, when we're looking at the financial estate, we look at characterizing the assets and the debts. Are they community property, such that we would divide them in half? Are they separate property of one spouse, so that we would parse them out? Or are they a combination? Once we determine the character, and by we I mean the judge, we look at valuation. In this case, oftentimes you are going to need forensic experts to assist you, and that is going to be an added cost and an added time constraint on the litigation process. Once you have characterized and valued the estate, the court is obligated to divide it equally with a few exceptions. So there is absolutely no room for negotiation. There's no room for thinking outside of the box. The parties are absolutely not in control. Quite frankly, the attorneys are not in control. The attorneys are advocates. We will advocate our client's position to the best of our ability within the law and the facts, but at the end of the day, the judge will make a judgment call on all of the assets and all of the debts in the case if the parties are unable to resolve the case outside of litigation.
And so let's say this process goes on for a long time, and I would imagine racks up a bunch of fees. What happens then?
The longer the case runs, typically the higher the level of the emotions. When you start out in a dissolution case, you're dealing with the emotions of the demise of a marriage and the anxiety and the fear associated with how I move forward with my life, no longer with my partner. As a divorce case runs on in litigation, and litigation cases can take an absurd amount of time. I've had cases that ran more than 10 years, which is terrible. And that is not unique. But when they run on and on through the litigation process, people become more angry at the process, at their soon-to-be former spouse. There's a lot of blame. They want revenge. Sometimes they get even more entrenched in the position that they have taken, and that interferes with their ability to step back again and try to look at the big picture of what is the cost of this litigation? How much has it cost me to get to this point? How much more is it going to cost me, and exactly what it is I'm hoping to gain? So in those scenarios, and in all scenarios, again, I see my role as continuing to remind and advise and adjust the focus if the costs become prohibitive and they significantly outweigh even the best case result through litigation. It's a pretty straightforward answer. We need to do something different.
Right.
And by different, you mean get together with the other side and try and talk settlement, whether it's in a formal mediation, or even just let's set up a meeting where we all get in the same room. Let's have Karen Casino, who's a forensic, and Peggy, who's a forensic, and Justin Ruckers, who isn't up here yet, where we all three sit down and try and figure it out.
Absolutely. I don't think that you can get through a complicated financial estate case, whether it's through litigation or mediation, without the assistance of forensics and financial planners. Quite frankly, they are our right arm through the process, advising us and our clients. Every opportunity you have to avoid litigation should be taken, whether that is through mediation, as you said, Karen, private conversations, private meetings. It enables the parties to have control over the outcome of their case. That is something that they will not have through the litigation process, but they can have through any of the alternatives, even arbitration or the collaborative process that Justin will be speaking of later. All of these are viable options, and they don't have to be utilized in the beginning. Sometimes emotionally people aren't ready in the beginning to discuss mediation. Right. But as we go through the process, revisit it over and over and over again.
We're talking with Leigh Galyon. Her website is herveywood.com. That's her website, herveywood.com. Give us a couple examples where keeping your eye on the big picture may have, I guess, assisted people in resolving the cases a little bit less painfully or less expensively, although they're commonly the same thing. Are there any good examples out there you can think of?
Well, there's a lot of examples. I have two examples that come to mind readily. One example of, again, thinking on a cost-benefit level has to do with tracing that Peggy is going to speak to shortly. It is very common in the family law setting that during a marriage, one of the spouses will inherit funds. Okay. And you're happily married, those funds go into a joint account. So now they are commingled. 5, 10, 15 years later, the parties separate, and understandably, that spouse wants their separate property money back. As a matter of law, if we can verify the separate property source, they're entitled to carve that out. The problem you have is it's been commingled in a joint account. Mm-hmm. In order for me as a litigation attorney to parse it out, I have to hire a forensic such as Peggy or Karen, and they have to trace it, either directly or through a family expense tracing. That's incredibly time consuming, depending on how many years have passed and how much activity is on these accounts. And it's incredibly costly. And again, Peggy will speak more specifically to that. But oftentimes what we see is the value of the funds inherited is significantly less than the cost we will incur in tracing. And if we can simply have a conversation at the outset, I understand you don't want to share that. But at the end of the day, you will lose the money, whether it's to your former spouse or to the forensics and the attorneys. Sometimes we're able to curtail the desire to go down that path. As far as an example of thinking big picture, the one case that is most prevalent in my mind is a case, it may be an example of failure along the way and an eventual success, but it is a case that I inherited after 7.5 years of litigation. I took over the case after the client hired me from the former attorney. It was dealing with a complicated financial estate, as they often do, commercial real estate holdings, private real estate holdings, investment interests, some of which were acquired by my client prior to the marriage. And this was a marriage of long duration, more than 25 years. 7.5 years of litigation, the parties had spent over $2 million in attorney's
Wow.
fees, forensics fees, and there was a receiver appointed on the case. They had sold off assets to fund the litigation because they were no longer young and working actively to support this type of litigation. When I came into the case, we had to candidly look at the reality. My client had a viable claim as to a separate interest in a number of the remaining assets. However, the cost to prevail through litigation would have required us to liquidate more assets. The capital gains taxes on those assets would have wiped out the majority of the equity. And at the end of the day, while we would have had a piece of paper that likely said, you win these assets, they would be gone. So, with the help of 3 forensics, business valuators, multiple meetings over the course of 4 months, my client made the decision to divide the estate in half.
I see.
At the end of the day, it was the smart decision to make because he walked away with viable income producing assets that he would not have been able to walk away with had we gone through litigation. So in that respect, it was success.
Sure.
7.5 years of litigation, I don't view that as a success. Had they been able to get to that point sooner, there would have been a larger estate that could have been divided. I don't know if that could have happened or not, but that is the unfortunate side of litigation.
A certainly unique story. We're talking with Leigh Galyon, family law attorney with Hervey, Wood, and Galyon. Her website is herveywood.com. That's the website, herveywood.com.